Recent changes to the federal estate tax exemption, part of the OBBBA, may have unintentionally created a problem inside many existing revocable trusts. We've run into this with a number of our clients. You see, if your estate plan was drafted years ago and includes mandatory marital or bypass trust funding language, it may not work out the way you expect under the new law. Hi, my name's Paul Carroll, I'm the CEO and founder of Avion Wealth. The One Big Beautiful Bill Act permanently increased the federal estate tax exemption to $15 million per individual, or $30 million for married couples beginning this year in 2026. Many of the trusts created before this increase were drafted when exemption amounts were much lower. To minimize estate tax at the first spouse's death, they often used what's called a reduced to zero formula, requiring assets to fully fund a family trust up to the exemption amount before anything passes to the marital trust. This is where things go awry. If the first spouse dies with an estate under the new $15 million exemption, the formula could direct 100% of the assets into the family trust and zero into the marital trust. That may sound harmless or meaningless, but it can create several unintended consequences for the surviving spouse. First, the surviving spouse may lose direct ownership of those assets and instead have only limited access under a health, support, maintenance, and education standard. Second, assets inside the family trust typically do not get a second step up in basis at the surviving spouse's death, potentially increasing capital gains exposure for their heirs. And third, the family trust becomes a separate legal and tax entity requiring its own tax ID and annual fiduciary tax filings. In many cases, this issue can be addressed while both spouses are still living. Replacing the mandatory shall language with a discretionary may language or incorporating disclaimer provisions can restore flexibility. The key is ensuring that your trust language aligns with today's exemption levels, not those from a decade ago. If your estate plan hasn't been reviewed since the recent tax law changes, this may be an area worth revisiting with your estate planning attorney and/or your wealth management team. At Avion Wealth, we coordinate alongside your legal and tax professionals to help ensure your wealth transfer strategy reflects current law and your long-term objectives. And of course, we're happy to provide a complimentary second opinion and even look at your estate planning documents to determine if maybe it needs a second look from an attorney, if that would be helpful. We wish you the best of investing success.